Hello. This is Attorney Mike Rebel coming to you from Chicago. As usual, I just want to say hey, happy St. Patrick's Day to everybody. I did a whole stream today, didn't say it. I thought it, but I didn't say it. I've got the St. Patrick's Day background. That should cover me. It's cold and nasty here in Chicago. I mean, I went out briefly. It's just horrible. It'll get better tomorrow, but it's just, that's the current state of affairs in Chicago. All right, so here's what happened. I'm over streaming the Afro Man trial, which is outrageous. It's fantastic. It's everything you'd hope for. And I don't think it will last long. So I think I'm going to do that whole trial. I did the first 2 days in 1 day today. Oh my God. It was out of hand. It was so much fun. Anyway, while all that's happening, and I'm streaming Afro Man all day, Zach over at LawNerdsUnite is sending me just all sorts of good stuff. So we got to do it now. Could be worse. I might even have a cocktail because it's St. Patrick's Day. I don't know. I haven't decided yet. We'll figure that out. Let's get this party started, shall we?
Felipe Contreras, that one's yours, correct?
Yes, Your Honor.
All right, that's set on default docket today. Do you want to move forward with that?
Yes, Your Honor.
We have some court to consider on behalf of your client.
Your Honor, the court is asking for damages in the amount of $10,416.64. The original lender on this was Santander Consumer USA. The current holder is Jefferson Capital Systems. The account was opened in 8/28 of 2018. The last payment was 10/21 of 2021. The account was closed 1/31 of 2022 with the balance of $10,416.64. The suit was filed 12/1 of 2025, and the defendant was served 12/16 of 2025.
Thank you.
Plaintiff is asking for damages in the amount sought plus court costs plus post-judgment interest.
When was charge-off date again, or last activity on the account again?
Yes, Your Honor. That was 10/21 of 2021.
And y'all filed on 12/1 of 2025?
That is correct, Your Honor.
Is it 4-year statute of limitations?
Yes, it is, Your Honor. Your Honor, this suit was filed after the statute of limitations. I just realized that.
Yes, sir. So what'd you like for me to do before I do?
That was actually pretty smooth. You got to understand the volume that collection attorneys are dealing with. The judge is asking the questions for that reason. It dawns on the attorney and he's like, oh, we're screwed. And then he just says it. He just comes out with it.
You can. I would ask that you just rule, Your Honor.
So I'm going to rule at this time that the statute of limitations is in effect in this case. The plaintiff has no jurisdiction to file since it was filed after the statute of limitations had expired.
Thank you, Your Honor.
You're welcome, sir.
Case dismissed. You didn't file with it. Boy, that's a short statute on a contract. My God, I think it's like 10 years in Illinois. But if it's 4 years, or it's 4 years and they know it. And there's lots of things like payment. There's a lot activity will refresh the statute in that context. But they just didn't get it on file in time. And I like how he said, just rule on it, Judge, because it's like, no, I don't want to go back and tell my client I dismiss it. You tell us that it's over. And then I'll just tell them that was it. We didn't get it on file in time. The end. It's not, it sounds like a big deal. It's like $10,000, but God knows if they'd ever collect it. And you got to understand the volume of cases you're dealing with. It's not the end of the world.
This is file number 112642DS, and the matter is captioned Bar versus Toner. So we have Miss Sarah.
Okay, I've only seen this guy a couple times, but I do like him, and I love his crazy hair. I really do. It's just really mad scientist, and he's all in. I also liked him I also liked in the last one the guy blamed the judge for not giving him enough information, and he was not having any of it, none of it whatsoever.
Barr here, along with Mr. Joshua Toner. They are parents that are controlled by an order entered by this court back on August 10th of the year 2015. Now, that order had set up custody, parenting time, and child support for their minor child, Corbin Mark Toner. And the parenting time was to be week on, week off. Mr. Toner now asked the court to consider changing that order in his most recently filed motion to change custody. Ms. Barr has not responded to that motion, so I'll just hear from her in a moment. So, Mr. Toner, if you would join me at the podium.
Yep.
If you would raise your right hand with me, do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hand down. I just want to tell you one thing before we proceed. Please don't ever bring a minor child that's a subject of these proceedings to court again unless the court asks for the child. You understand?
Understood.
The child, although is a subject of these proceedings, the child should not be a part of these proceedings. And by bringing the child here to the courthouse, you've made the child a part of it. And his job is to be a kid, not to be a litigant. And that's the position you put him in. There are very narrow circumstances when the court can interview a minor child. And today is not one of them. Do you understand?
Understood.
All right. So now you're asking the court to change custody. So you go ahead and tell me what's happened since that order's entered that you believe requires a change of custody.
So, in early January, Pete approached me and told me a circumstances that occurred between him and his older brother. And
now that older brother is not your child, correct?
Correct. And that's been going on for 3 years. And he's been telling his mother that for the past 3 years, and nothing's ever happened. He told me that, and I filed a police report.
I don't know if I want to know what's going on here
Immediately, and that's ongoing with the Laingsburg Police Department.
You've had Corbin then in your custody since January?
He's been at my house since then, yes.
And has mom objected to that placement?
I've not heard from his mother at all since then, other than last Friday when she told me that he had a dentist appointment.
Oh, okay. All right. Is there anything else you wanted to let me know, Mr. Toner?
No, that's it.
All right. Thank you. Ms. Barr, would you join me at the podium, please?
May I bring my...
Sure. Would you raise your right hand? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
You do.
Thank you. You may put your hand down. And then how would you respond then?
So I received this notice to parties without attorneys, with the lettering of A through J.
You've received what?
The notice to parties without attorneys.
Oh, okay. Yeah.
With the notice to appear. I responded accordingly to each of those letterings.
You say you did respond?
I've written. I can written response.
Why didn't you file them with the clerk so that I could read those responses ahead of time?
Due to the nature of how the last 2 months have gone, the death threats that I've received from Corbin personally against me, telling me that I fucking deserve to die. I don't deserve a place in this universe. Threatening to kill his brother, threatening to send his brother to prison, and that if I know anything at all, I know what happens to fellow inmates in prison that with these allegations.
If this is what I fear it is, I don't blame him.
So Corbin's pretty upset then.
They get killed. So due to the nature of the context of the communication that Corbin has relayed to me, I have not responded.
So you didn't file a written answer to the written motion because.
I didn't receive this documentation in the mail until last week.
Okay. All right.
Yeah. So I guess at that point I had no time to respond.
Is it true that
Josh sent me something?
I don't know why you're talking over me. Is it true that Corbin has been living with Dad since January?
That is correct.
Is it true too that you have not reached out to Dad until just this last Friday to let him know that Corbin has a dentist appointment?
That is correct.
All right. I know it's true that you have not filed a complaint with the friend of the court alleging a denial of parenting time. Do you agree with that statement?
That is correct.
And can I assume that you do not object to the request by Mr. Toner to change custody?
I do object.
You
Corbin,
do object.
I do object. Corbin has a history of going back and forth for extended periods of time at his will between his father's house and my house. Last at the end of June, beginning of July, my son overdosed under his roof, ended up in the hospital, went to a rehab for a week. I reached out to a therapist. Prior to that, I had initiated medication regulation. I reached out to his primary care provider. They referred him to a psychologist.
When was this overdose that you described? When was it?
July.
In July of last year?
July of last year. So after that, Corbin was upset with his father because he's the one who called 911 on him. And so for a 2-month period after that, Corbin was at my house and his father at that time did not object.
I see. So what is it that you'd like the court to do today then, Ms. Barr?
I would like the court to keep the legal parenting time or the legal custody and the physical custody in place as 50-50 week on, week off.
So the child has been living with Dad since January and you've had no contact with him, but you want the court to order him?
I've had contact with him.
Talk over me again and this hearing is going to be over very quickly. You admitted to me that you've had very little contact with him just now. So you have had contact with Corbin? You have had him?
I'm sorry, I misunderstood. I thought you were speaking contact with Mr. Toner.
I'm talking about the child.
Okay. I have had contact with him.
You had parenting time with him?
No, he has refused to come to my house.
Well, it seems to me that a reasonable parent that has been denied parenting time for almost 90 days would, at the very least, contact the friend of the court and let them know that I'm not getting my parenting time pursuant to the order. I'm being denied my physical custody. But you haven't done that, correct?
Correct.
All right. Is there anything else you'd like to say?
No, sir.
Thank you. You can return to your seat. This is a threshold hearing, and this is not, you all right?
Yeah, okay, thank you.
This is not a hearing to determine whether or not it's in the best interest of the minor child to change custody. See, children thrive on routine. They thrive on consistency. Our legislatures understand that. So before the court can change custody, it must first have the party that's seeking to change custody satisfy a threshold. Like there's been an important material change in circumstances in the life of the child that would warrant a review of the existing custody order. That's the purpose of today's hearing. It's a threshold hearing. In other words, the parent seeking custody has to convince the court that there's been some change, that there's a proper cause to move on to a best interest hearing. That's what we're doing today. And the court does find that Mr. Toner has satisfied that first prong. He has satisfied that threshold. There's a statute that allows a court's friend of the court division to contact Child Protective Services on a pending custody or parenting time matter. And in this case, my administration did contact Child Protective Services on this case and this family. As I understand it, an investigation is ongoing. It is not complete. It is still ongoing. I don't have an answer yet. Chief DeCourt from Langsburg Police Department has not finished his report. When he does, he will get it to Child Protective Services. Child Protective Services, not in Shiawassee County, in Ingham County, then we'll decide what they're going to do with this family. So in the meantime, I think the most prudent thing to do is to maintain the status quo. That means Corbin stays exactly where he is for the time being, and that will be with Dad. So moving forward, the court will amend the existing custody order to award father temporary primary physical custody pending a full evidentiary hearing as to whether or not it is in a child's best interest that custody be changed. So I'm going to refer this matter to my referee who will conduct that evidentiary hearing. But in the meantime, I think Corbin should stay put where he is. I'm not hearing from Mom that there's any problems over there other than perhaps she says an overdose last year, which I don't know about that, but it seems to be where we're at right now is working, and that'll continue. I'll allow parenting time to continue as the parties agree. Since no complaints have been filed with the front of the court, I assume there are no complaints to be made. And with that, I'll give you a copy of the order before you leave today. And the referee's scheduling clerk will reach out to you and give you dates on when they expect you to return from court. Thank you all very much.
Thank you.
All right, those parties in position 5 can go ahead and turn their camera.
Aye, that was ugly. I think the judge did the right thing, but it was ugly.
Cameras on and unmute. That's Jose Angel and Jermaine Nathan Shaw.
Your Honor, how are you doing today?
I'm doing well. All right. And then I'm also looking for Nathan Shaw.
This room is usually good for some stupid.
I'm looking for Mr. Shaw. Mr. Shaw, unmute and turn on your camera. Again, Mr. Shaw, where is? I see you're there. I need you to unmute and turn on your camera. Be patient.
Hello.
Yep, turn on your camera. All right, raise your right hand. You as well as Mr. Castro. Mr. Castro, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law? Mr.
Yeah.
Castro, is that a yes?
Yeah.
All right, how about you, Mr.
Yes, Your Honor.
All right.
Yes,
Is
Your
that
Honor.
hard?
All right, great.
It wasn't
I
a
ask
trick
each of you
question.
some questions. You guys can put your hands down and we'll find out. No reason to speak over one another, okay? Position 5, let's talk to the plaintiff, Mr. Castro. Is this a written or oral lease that you have with Mr. Shaw?
I have it written, lease, Your Honor.
Okay, and when is it set to expire?
Lease that I gave him a month-to-month lease
Okay, so
due to the fact that
I don't know if it's my connection or your connection. I'm not sure.
my connection seems a little shaky. Let me see if I could. Can you hear me now, Your Honor?
I can, Mr. Castro. So it's a month to month. How much is monthly rent?
It's $2,800 plus after the 15th. I stated to him if there is, because basically I'm getting a late fee every 5th of the month.
Well, you know, we cap late fees or whatever at 10%. So we capping it at $280.
Correct. So it was $2,800 a month, the mortgage. And then there was assessed fees every month, late fees, which on top of that, due to the fact that since he moved into the property, he has been paying late. It knocked on to my net, which brought my mortgage up. Also with the property taxes, almost up to $3,000. So he's basically paying under what I pay, and he's not paying me on time, and he's partially breaking down the payment. So that's caused me to be backed up on my payments and has had the bank return me the check, the money, because they want the money in full. And due to the fact that he pays me, let's say, if it's the 15th, on the 18th, the 28th, 2 weeks later.
I got it. But in all actuality, all those things are inconvenient. But we're dealing with a contract, and obviously we're capping it at 10%. So I understand what your allegation is. And so last time he paid rent.
Last time he paid rent was last month, and he paid on partial payments. He paid
in February?
He's supposed to be paying by the 15th. He's right now he's due this month.
Wait, listen, see what it always makes me chuckle. Listen, when's the last time he paid you and how much?
Last time he paid me was a month ago, and he paid.
No. What day? Because people think sometimes a month ago is January, and sometimes people think it's February in their mind. So tell me what a month ago is to you, and what day? When did you get?
A month ago, I will let you know, because it's difficult because he pays sporadically. It's not like he pays in full. He just pays.
When's the last time you got some money from him?
3 weeks ago.
2-3 weeks ago. What day?
He was supposed to pay it by the 15th. He paid he paid the 31st of the 1st. So he's
of what month?
Of this month. Of this
January?
month.
Say the month, sir. I don't need this, that, last specifics. January, February, March. When did you get a payment last? March 1st, February 1st, January 1st?
February.
Okay. So February 1st or 31st?
February, like he paid for the February, but he paid late. Like 60, he's already 60 days late.
So you're not getting me.
So February.
Okay. But when is the last time you received any money from him? So was it on February 1st that you received some money? 2nd, 3rd, 4th, the 28th? When did you receive last time you received some money?
It was I think it was the 1st or the 31st or the 31st of the ending of the month of January.
Okay, so either the 1st of February or the January 31st.
Yeah.
Okay, and that was to pay for, and that would have brought him current through what month?
That would have brought him currently for the month of January, because he's paying 30 days late.
I got it. So he now owes for February, as well as if I were to give a writ of possession.
That's false.
Mr. Shaw, I didn't ask for you to say anything right now. So please.
Oh my God.
Yeah, don't do that.
Oh my God.
Don't do that. So as I said before, you're saying February,
painful,
as well as if I were to give a writ of possession, 24 days in March. Is that correct?
Correct. As of the contract, Your Honor, from what it states, tomorrow, which is the 15th, right? He's supposed to be making a payment for the month of that he's living in now of March, right?
So the payments are due on the 15th, or are they due on the 1st?
They're really due on the 1st, but due to the fact that he never paid me on time, and the day that I actually gave him the lease, I'm like, look, I gave you the lease the 15th, and I know that now.
The payments aren't due, so it's the 15th through the 15th that the month start?
No, the month starts the 1st. I told him from the beginning it had to be from the 1st to the 5th. I've tried to help this gentleman out.
I understand, but you listen to me. You have an oral now month-to-month agreement. Is that correct?
Correct. Correct. Oral, yeah, and a lease as well.
All right, and a lease. And you're saying he hasn't paid since January, and ultimately he's got that month as well as the dates that if I were to give him 7 days for an eviction. Okay. You're saying the rent is $2,800. The court of course caps it at $280 as far as a late fee. And that's it. Outside of that.
Yeah, he would just, to me, because I'm fair, he would owe this month, right? Because he's already lived out this month, and the late fee. That's it.
Well, maybe not lived out this month, because I can only give him 7 days. So let me hear from Mr. Shaw. Mr. Shaw, I'm going to ask you a couple of questions. Just answer the questions. So, Mr. Shaw, do you have a written lease with Mr. Castro?
Written, yes, sir.
And when is it set to expire?
It's 1 month of the month on the 15th.
Okay. And you're saying your payments are due on the 15th?
Yes, sir. And the last payment he got from me was on the 28th of February. So it wasn't.
On the 28th of February. And
Yeah,
how
I've
much?
been paid on, so I only owe for March. The only reason why I held
Wait. Just stop, man. Stop, please. Let me ask the question so it won't have to be long, truncated. It's all right. I've been doing this. Let me do my job. It's all right. You don't have to be
Do your thing.
Yeah, thanks. So bring your face back in the screen. It's all right. It's all right. So you're saying you paid him on the 28th of February. How much money did you pay him on the 28th of February?
It was pieced up, but the last piece was 500, so it was a total because I don't have Cash App, so I had other people send Cash App, but it was a total of $2,600. It was 13. It was 13.
All right, hold on. So slow down because maybe I'm a little slow. So you paid him $500 on the 28th.
That was the last portion of.
Okay. That you're jumping to conclusions. I'm just trying to look for facts.
Yes, sir.
You paid him $500 on the 28th of February. Yes or no?
Yes, sir.
And how did you pay? How did you pay him?
It was Apple Pay.
Okay. Did he return that money back to you?
No, sir.
Okay. You pause right there before you tell me anything else, Mr. Castro. He's telling me that he gave you $500 via Cash App on February 28th. Is that a yes or a no?
Yeah, he sent me money.
Okay, so we can stop there. Let's stop. Let me tell you why we're going to stop. So you know when you file a case, which was made on February 4th, 2026, and if you don't know, I'm going to remind you, you are alleging that this is the amount of money you want, and you're wanting the court to take over and make a decision. When you accept money after you file, you're essentially saying otherwise. And you're saying, you know what? I've taken some money and now whatever you've pled is no longer true, right? Because you've taken money since then time. Things change, balances change. That changes the whole case. You can't proceed and take money after you file. That's a rule. So when you take the money, that causes the case to be dismissed. That doesn't mean that you can't refile. Okay. All right, Mr. Shaw. Yeah, okay. If you can just not have your shirt on the screen. All right. So it doesn't mean that you can't refile, but you can't take the money, man. And I do understand the financial frustration that it's putting you in. So I'm not disagreeing with you. I'm not making light of that. But I'm telling you, there are rules and requirements when you start getting the court involved. That's why we often communicate to people that, you know, you might want to consent, not because we're saying that you're going to be charged if you don't, but what we do is hold you to the law, right? And so it sucks, right? You're like, man, I just ain't paid. He ain't paid, but he did pay. And now I'm going to end up getting the case dismissed. Why? Because unfortunately, you didn't follow the law regarding this matter. And I can't give you what you want, which is a legal result, right? Which is you get a writ. You're not going to get that writ when you accepted the money after the fact. So I'm going to dismiss the case. Don't, Mr. Shaw. It sounds like y'all might be really close. It sounds like there may be 1 month, maybe. And so maybe you guys can resolve. But for today, because of the acceptance of rent after the fact and no return, the case is going to be dismissed. Okay.
So quick question, Your Honor. I'm going to have to refile for court again.
Mm-hmm. And follow all the statutory requirements. So
and then wait, and then he's late 30 days every month. So now I gotta wait another 30 days and not get payment from him.
Yes, dummy. You screwed up. Yes. That's what it means.
Mr. Castro, I'm frustrated for you, but I didn't accept the money on the 28th. I didn't tell the court when I first asked you to list the questions the last time you got paid. You had an opportunity to tell me it was February 28th. I asked you several times.
So even if somebody gives
No. Don't get loud with me.
I'm not loud. I'm just
take it down a couple notches.
I'm sorry. I'm talking through an iPad, so I'm trying to hear you.
It's okay. All right.
So I'm sorry about that. I'm not trying to raise my voice.
I understand. And I understand it's frustrating, but let me tell you again so you don't make the mistake twice. You accepted money after filing. You are now causing the case to have to be refiled. So yes, it is an inconvenience. I don't want that inconvenience for you, but if you follow the law, then you won't have to worry about the inconvenience. All right?
Another question.
One last question before I let you go.
So now, due to the fact that I'm losing my house on pre-foreclosure due to this issue, I'm going to sell my home. This week, I already put a contract out with another company. So if the company now takes possession of the property and they have a quick claim deed on the property, then they have to go through the process of evicting.
Everybody has to go through the appropriate process to evict people. There ain't no skipping steps. No skipping steps. All right. Not if you want the court involved. You can't skip steps. All right. That's all. And I appreciate your time. I hate it happened to you, but you got to follow the law if you want the law involved. All right. So Mr. Shaw, Mr. Castro, you're free to go. Thank you so much. All right.
Well, that was
And are we still waiting on the last case?
Thank you. And then we are on the record in the matter of Mark Jakubiak versus Donnell Hamilton 2600141. I do apologize for your delay.
Gotta remain my client said, please.
Yes.
Thank you.
Your Honor, what do you say? Yeah, right here.
Yes, in just one moment. That's okay, sir. I think that we have somebody else coming in.
What do you want?
Hold on, can you, where's Bobby and Dave?
Bobby's in the back. I don't know where Dave is. They just asked if somebody could come in.
Bobby's in the back where? Like the back
He
back?
took Mr. Jackson back. He's back there with Jackson.
Do we need something? Yes, we need Dave. Can you still find him?
Where's that voice coming from?
Student.
Okay, and so counsel, your appearance, please.
Good morning, Your Honor. Galito Taylor, fee number 8227 was on behalf of plaintiff Mark Jakubiak.
All right, and
I got open afro,
sir,
man.
your
I don't
name
know
for the
how
record,
to deal with
please.
it.
Donnell Hamilton.
Okay, and so Mr. Hamilton and Mr. Jakubiak, I'm going to ask you to please place your name on the record, sir.
Mark Jakubiak.
Okay, and so I'm going to have you both please raise your right hands. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes. Yes, sir.
All right, thank you. Can you have Mark come in? Somebody else can.
He sent Dave, Mark's at the door. He sent Dave a message to, I don't know where either one of them are.
Okay, and so counsel, today's the date scheduled for a hearing in this matter. And you have you spoken to Mr. Hamilton today?
Mr. Hamilton and I have not spoken. There's no agreement on this, Your Honor. He did deliver more documents to my office this past week.
All right, and so there is a claim. So Mr. Hamilton indicates that Mr. Jakubiak is not the owner. Is that correct?
I never had proof that he was the owner.
Right. Okay. So Ms. Taylor, did you submit proof to Mr. Hamilton that Mr. Jakubiak, Mark Jakubiak, was the owner?
In the documents that were filed with the court with the summons and complaint, there is a copy of a warranty deed that should have been sent with him for service that shows he is owner of the property, Your Honor. And I do have that deed with me today.
Okay. Well, I asked if you sent that to Mr. Hamilton since the last court date.
I did not, Your Honor.
Why not?
I just assumed it was in the packet, Your Honor.
Well, Mr. Hamilton seems to not have that information, which is why I expected that was all documents were going to be exchanged prior to today. Sir, do you have a copy of that in your packet of information?
I do. I have when they sent the court letter from the eviction letter that I got, that's when I was able to realize that it was in that document. But prior, when I asked for it at first, I never knew it.
Sir, you have that all in your documentation.
Just got it from those paperwork that they mailed me. That was from.
Sir,
Go ahead. I'm sorry.
when did you receive those papers?
When I finally went through my mailbox, so I can't remember the exact date, Your Honor.
Was it before your last court date here, sir, on March 6th?
No, it wasn't. I never looked through the whole document, so the only thing I seen was the date of the.
Sir, let me see your packet of information that you received in the mail.
I don't have the packet. The only thing that I brought was the deed that you said.
Okay,
So-
and so now you see that Mr. Mark Jakubiak is an owner, correct?
Yes, ma'am.
Okay, great. So do you have any objection? So council, so had the two of you spoken beforehand, you would have known that Mr. Hamilton agrees that Mr. Jakubiak is now an owner. So now Mr. Jakubiak wants to sell the house, correct?
That is correct, Your Honor. We're just seeking possession only, Your Honor.
Okay, and so Mr. Hamilton?
So the reason why, only thing I was seeking, like I asked Mr. Jubek, was for my security deposit, and I heard what was stated from a couple days after, or which was a week after. I also brought to the knowledge that when they rented the property out to me, there was no orders, order compliance or certification for them to even rent this apartment out to me. So my only problem was just me getting my security deposit back. And I have both documents stating from 2023 of June 28th of violations and also October 22nd, 2025 of violations of no compliance certificate.
Okay, so council, Mr. Hamilton's asking for his security deposit back. How much is his security deposit, sir? Sir, how much is your
Oh,
security?
it's 700 on my lease.
I'm sorry?
700.
700.
Yes, ma'am.
So Mr. Jakubiak's asking for his security deposit back.
Mr. Hamilton's asking for.
I'm sorry, yes.
This is clear record. Your Honor, Mark Jakubiak has just became the owner when his brother died. The lease agreement was between his brother Francis Jakubiak and Mr. Hamilton. Francis received, if he received anything, we don't know, but there's no receipt of any security deposit being paid. That lease agreement is not between my client and Mr. Hamilton. My client is seeking possession only based since his brother died. He needs to sell it.
Okay, Mr. Hamilton, I need you to pause moving all the paperwork because it's affecting the recording. Okay, just because that microphone's very sensitive. Sir, did you file a counter complaint that you're asking for the security deposit? And for what purpose would you need the security deposit since you have not even relocated yet?
I would need the security deposit so I can be able to relocate. The reason why I'm asking for it back is because the money that I do have is going to be completely drained out of my bank account. Because as of right now, like I stated when the last time I was here, I'm going through physical therapy and my doctor has me on limited duty at work right now.
Okay.
So that's one of the main reasons why.
All right, and sir, I can appreciate that, but there's not a legal basis at this point for me to order your security deposit to be returned before you've relocated. Typically, a security deposit can be returned after a person moves out to make sure that the person's entitled to that security deposit. Okay, so I don't have a legal basis, sir, to order Mr. Mark Jakubiak to provide you back with that security deposit. However, counsel, just so you're aware, your client's aware that I'm going to presume that Mr. Hamilton's going to request his security deposit to be returned to him at some point. So I don't know if Mr. Mark Jakubiak is the representative for his brother Francis, or if you are, I don't know, but somebody's going to have to rectify that because that is going to become an issue, it appears. So.
Duly noted, Your Honor.
Okay. All right. So, Mr. Hamilton, I don't have a legal basis to not grant their request for you to relocate.
Could you say that one more time for me?
I do not have a legal basis to not grant the request by Mr. Jakubiak for you to relocate from the home because he wants to sell it.
You got a GTFO, dummy. I'll make it real simple so even you can understand.
Could you break that down for me just a little bit more if possible?
Yes. Mr. Jakubiak's the owner of the home
Right.
by warranty deed. He wants to list the home for sale. He's requested that you relocate. I don't have a legal basis to not grant that request. So if I have a legal basis to not.
He really did this. He did this in an eviction.
I want to dumber down the ticket. I want to fight that.
Granted, then I can consider that, but
Well,
I don't have a legal basis to not grant that. Whether or not it was properly registered or not, that's not for this court at this time. Mr. Jakubiak's the owner of the home. He wants to sell the house. He needs for the tenants to be removed so he can get the house ready for sale and sell the house.
okay.
Okay?
So what I'm basically saying is I have no problem with that, and I stated that already back in October when sorry for his loss, when his brother first passed away. I stated that when he first passed away, I asked him, can you make repairs to the apartment, or can you give me my security deposit back, and I'll gladly move out of this apartment.
Okay, but so you're not entitled to your security deposit to have you move out, right? That's something that happens after you've relocated.
I understand.
Okay.
So the part that I was trying to get an understanding is because like he did say, well, the young lady just said is that, well, I didn't have the lease with Mark per se. It was with Francis, his brother.
Okay, sir, hold on just a moment.
Okay.
At this point, right, unless there's some other agreement, you're going to have to move by March 27th.
I wouldn't be able to move by March 27th.
Okay, why not?
Because I'm living to that break right now. Like I said, I can't really work too much, so I would need more time than.
Okay, what is it that you are requesting for additional time?
I'm looking for about 45 days.
Sir, you've had notice since October.
I have not.
Counsel, if you and Mr. Hamilton would have spoken beforehand, I wouldn't have to go through this exercise right now. Is there additional time that your client's willing to give Mr. Hamilton?
No, Your Honor, my client has not received any rent. He did ask for rent. As he stated at the last hearing, he has approximately $2,100 in his bank account that he has held because he did not pay rent. He has the means to move. My client has a buyer ready to close. We are asking for rent to be issued in 10 days.
Okay, well, Mr. Hamilton, I don't have a legal basis to not grant that. You've had notice since October, sir.
Ma'am, I have not had it notice since October. I had the notice when I set the notice. And that's when I asked the mark to fix the property, maintain the property, and then I could pay the rent. That's why I had to file the police report that I submitted towards you, and then with the threat.
You're not in front of Judge Simpson. It would work there. I grant you that, but you're not.
Of everything. I tried to work everything out with the mark and then also his lawyer. I filed a police report because I was getting made threats of this.
Sir. I hear what you're saying, but it is not necessarily relevant to the proceedings today. There's not an agreement for another date for you to move out. What the court will do is the court will indicate that I will give you until March 31st. That's 4 extra days. So the court will note that judgment will enter for the plaintiff and that defendant is to relocate by March 31st. No money judgment at this time. And the court's not ordering any, because you're just asking for the defendant to relocate, correct?
Correct, Your Honor.
Right. So there's no money that's owed or anything of that nature. And that's the order of the court.
I'll submit the judgment to NYP filing, Your Honor.
All right. Thank you.
Thank you.
All right. Have a good day.
You too.
Have a good day, sir.
Please.
What's that, sir?
And the reason why I was trying to get to the point that I was trying to get to is this has been the trend with him and his brother before the brother even passed.
Hold on, sir. Tell me how that's relevant.
I'm trying to,
Mr. Mark Jakubiak wanting to sell the home.
because at this point it's a retaliation. It's a retaliation eviction.
Sorry, the court does not find it's a retaliation eviction.
I'm trying.
Excuse me, just a moment, sir. Mr. Jakubiak is looking to sell the home. If he doesn't sell the home and he rents it to somebody different and he's not selling the home, then, sir, you may have some type of action. You'd have to bring that back before the court. But at this point, the court's not finding, sir, that it's a retaliatory eviction because Mr. Jakubiak is wanting to sell the home.
So he doesn't have to show any proof that they're trying to sell the home. There's no proof that
Sir, I have to take his attorney, who's an officer of the court, I have to take her word for it. If, sir, Mr. Jakubiak does not sell the home and he then rents it to somebody else, then that's another story.
How do I go about proving that?
Well, I can't give you legal advice, sir. You'd have to speak to an attorney. I'm not allowed to give you legal advice. Okay?
So out of everything I'm trying to show that even before the brother passed, every time I ask for a repair to get done to this property, I get an eviction letter in my mailbox. They don't even submit the proper. They don't even submit it to the court properly, and it's always been like this. I even have my proof. I even have my statements of proof that I paid.
Okay, so what that tells me, sir, is that it's not a great property to live at and you'd want to move.
I have no problem with moving, but you're just told me like even when I do move, I can't even get my security deposit back.
I didn't say that, sir.
Well, I misunderstood you.
I didn't say that.
Sorry.
I said today, right? It's too premature to request your security deposit back. There's no legal basis to get that back before you've moved out,
Right.
right? After you move out, then there's a certain way that you go about requesting your security deposit to be returned.
Okay.
Okay.
And then also too, my counterclaim that I had going, you know, what I said with the two violations coming from 2023 to 2025, they weren't even supposed to rent this up.
Sir, you continue to live there.
I didn't know, Your Honor, until October 22nd. This
Okay,
was in
sir.
compliance.
Okay.
I never.
How does that affect you relocating for Mr. Jakubiak to sell the home?
It affects me because I have to move.
Yes, you have to.
Continue working. I gotta stop everything I'm doing to go find another.
Okay, but sir, you've been given much notice that Mr. Jakubiak wanted to sell the home
No, I did not.
and that he wanted you to relocate.
No, I did
You've been
not.
given a much notice, sir. When did you receive your notice to quit?
I don't know. I never received anything. Only thing I never
Sir,
received anything until I got.
if you think that it's retaliatory eviction and Mr. Jakubiak does not sell the home and then rents it to somebody else, then you can bring that back before the court. Otherwise, the court's made its order, its ruling. Okay,
Judge.
good luck to you, sir. We're on the record in the matter of Richard Custer versus Jenny Garcia, 2600002.
So once I move out, then I gotta come back here to get security.
Sir, I'm on the record on another case. You have to speak to an attorney if you need
Oh my
additional
God.
assistance.
Shut up and leave. You suck.
You, Mr. Custer?
Yes.
Okay, I'm gonna, all right. And are you Miss Garcia?
Yes.
Okay, well, I'll have the two of you stay there. Is there an I'm gonna, Mr. Custer, your name for the record, please.
Richard Custer.
Okay, Miss Garcia, your name for the record, please.
Jenny Garcia.
Okay, and so, is there a resolution between the two of you?
Yes, but the first thing I did give you this, please.
What is that?
This is one of the houses they try to sell for laundering.
She did, Mrs. Garcia did. Ma'am, you're not identified for the record, so please don't say a word.
I'm gonna.
No, sit down. You're not identified for the record.
Okay, wait a minute.
Hold on, sir. All right. So there was a prior land contract case with judgment. I made a note in here. And then Ms. Garcia claimed that she made payments.
Well, we've got that all resolved, Your Honor.
Well, okay, but you indicated there was a prior land contract with a judgment.
That's finished. Now, the situation there, they tried to sell the house and I didn't authorize that.
Okay,
I just.
what, all right. Before we get to that, what is it that you're stating is the resolution between the two of them right now?
Says she's gonna be out by April 15th.
Okay. And so then no other monies are due and owing, she's just going to relocate, is that correct?
Relocate.
I'm sorry, sir, when I'm talking, you can't talk over me because the recording can only get one of us at a time.
Thank you.
Okay, so please keep your hands out of your pockets. So let me confirm. Ms. Garcia is going to relocate by April 15th. Is that correct, Ms. Garcia?
Yes.
And then there isn't any other money due. Is that correct, Ms.
No.
Garcia? Is that correct, Ms. Garcia?
Yes.
Is that correct, Mr. Custer?
Yes.
When you said not at this time, what do you mean?
No, I'm gonna forget about it. I'm gonna worry about it.
So let me ask this question as well. So there's already been a land contract case that this court granted judgment on. Is that correct? That's correct. And then you did not foreclose on that, requiring Ms. Garcia to leave. Is that correct? That's correct. And so when was the date of that judgment again? I know it was almost 2 years ago. Okay, so now she's been continuing to reside in the home. Yes. And now you filed this as a non-payment of rent case. Yes. But it's a it's a land contract case. That was null and void 2 years ago. You already voided that. There's no talking in court. I voided the land contract. All right. 2 years ago.
Coochie. Gotcha.
I don't recall voiding the land contract, sir. What it shows. So let me take a look at that judgment. This court says an order of eviction. So the judgment of possession for a breach of a land contract is entered. An order of eviction may be issued upon expiration of 90 days if defendant does not pay the total amount due. A money judgment for damages, and then it has that $21,000. Okay, that was by consent. Okay, and then you did not move for eviction at that time, correct? We started to, and then she said she was gonna try and buy the house. And there was just other circumstances. Her mother died. She didn't get the money she thought she would get, and she sold the house. She didn't get the money she was supposed to get, and I can't wait any longer. Okay, well, this is a breach of a land contract. It doesn't necessarily say that the land contract is now void. I don't have a copy of your land contract to see what that reads. And she never paid anything since then. And this wasn't 2 years ago. This was 5.5 years ago. This right. Don't start. Sir, hold on a minute.
No, he was talking to me.
Yes, I know that he was talking to you.
I'm sorry.
That's not how you talk to another person, sir. What was it that you said, ma'am? What was it you just said to him?
He said I hadn't paid anything. I just said I paid something. I was telling him.
I understand that. So how much did you pay?
Since what year? I have this right here.
Since 2020, how much have you paid?
She might have sold some burritos.
I have these. Want to take?
No, I need you to tell me for the record, ma'am, how much have you paid since October 23rd of 2020?
These add up to 7,100.
Since October 23rd of 2020.
It's more than that, but my checks would add up. That's all the proof I have. 7,100.
All right, so sir, why are you telling her not to start? Because right here, she's got a $4,300 water bill she didn't pay. And I'm waiving all that stuff.
Yes.
Okay.
She's supposed to pay $650 a month on the water bill, and I paid the last 3 payments. But all I want to be is out of this thing, and I want to sell a house.
So ma'am, you're agreeing to move by what date?
April 15th.
Beautiful. Go.
I asked. Oh, longer.
He's just been simping. That's all there is to it. This is.
Ma'am, you got a long time to figure this out. 5.5 years, quite frankly.
Okay.
They got nothing but time. Apparently.
Okay, the court's going to indicate by consent that plaintiff is entitled to recover possession of the property, that defendant is to relocate by April 15th. If defendant does not move out by April 15th, plaintiff will apply for an order evicting the defendant. Please keep your hands out of your pocket, sir. And additional money may be owed if damage to property occurs or rent continues to accrue. And additional partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter.
Yep. She's got to go.
And then I will make a note that since you're in pro per, the court will have to draft the judgment. Ma'am, this isn't school. What can I help you with?
And approach.
What's your name?
Renata Ballas.
I need you to spell your first and last names for the record, please.
Renata, capital RAE, and then Ballas, B like boy, ALLAS.
Okay, and what is your relation to the case?
I am the realtor for Mr. Custer. I've had the property listed for 2 years now, but I haven't been able to do anything because of the situation.
Okay, what is it you can add to this?
On March 11th, I received a call from a company called J Park Realty. Evidently, I was told that Ms. Garcia went in there, signed paperwork to list the home, while the home is currently listed under my MLS. And
Okay, so how does that affect this ruling
She's
of the
trying to
court?
sell the house. She doesn't. Oh, geez.
I don't know that it affects the, Your Honor, I'm not sure, but what I was going to ask is if you can order her not to go to any more real estate companies and try to list this home.
Well, ma'am, I would love to order that. However, that's not an issue before the court.
Okay.
It's up to her. It's her peril if she's going to continue to fraudulently try to sell a home that she doesn't own. And shame on whoever she signed a listing agreement with, that they didn't pay attention that she wasn't the owner. I have no idea. But
that's when they contacted me and let me know what was going on. I was
Grandma sleazy right to the end here. Oh my God. It never ends.
a little bit confused because they're asking me to take the listing off, and I said, why? I'm not under contract yet. It's going through litigation.
okay, ma'am, let me be very clear. You're not the owner of this home, are you? Is that no?
No. Yeah.
Great.
No.
You have zero standing to go file anything for sale of the home. Nothing. You don't have that right. If you're proceeding along that path, ma'am, you could be facing criminal charges. So you may really want to rethink your process.
Okay.
The court will sign that as soon as it's done. Have a good day.
Thank you.
Off the record.
Oh my God.
Thank you, Your Honor. You're welcome. Have a good day.
Folks, let's go ahead. Those parties in position 3, we'll deal with position 3. That's Ms. Muhammad and Balogan. Go ahead and have you both unmute for me.
Okay.
Just wait.
Can you
Yeah, just hold tight before you start talking.
Okay.
I'm just waiting for Mr. Balogan to unmute.
Okay.
All right, can I have you and Ms. Muhammad and Balogan to raise their right hand to unmute? To get under oath?
I might have
You
to
as
go
well,
get
Ms.
a call.
Muhammad. Let me see your hand in the screen. You swear or affirm to tell the truth under penalty and perjury of the law? Is that a yes, Muhammad, Ms. Muhammad?
Yes, I affirm.
And Ms. Balogan, Mr. Balogan?
Yes, I do.
All right, folks. I'm going to ask each of you some questions. Put your hand down. I'm going to ask each of you some questions. Yes, Ms. Muhammad, you had a question.
Yes. My husband, he couldn't be here, but I have him on the phone as well, because he is a witness.
Yeah, well, that's not going to satisfy him being on the telephone, okay?
But
Okay, because I thought maybe because we was on visual.
I would need to see who I'm talking to at least. But let's see what's going on first. All right, let's see what's going on. All right, so Mr. Belogan, I'm going to ask you a couple of questions regarding the matter. All right, first and foremost, do you have a written lease with Miss Muhammad?
In the beginning, yes, but it transferred to month after she's been in the house at least about 4 or 5 years.
Okay, all right. And when did it change to month? Do you recall?
At least for the last 2 years.
Okay, and how much is monthly rent?
1,000.
Okay, and is there a late fee?
Yes, 10%.
Okay. Last time rent was paid from any source, or you received any money?
That will be about 12 months ago, about a year.
About a year ago.
February, March.
Of 2025?
Yes, sir.
Okay. All right. Anything? I know I did see on the complaint that you allege that she owed you $10,000 as of January of 2026. However, you did not put any future rent amount on the complaint. So if I were to have fined for a judgment for you, I don't understand I am, it would be capped to $10,000. Okay.
Okay.
All right. All right. Now, Ms. Muhammad, I'm going to ask you some questions. Okay. Just first confirming, did you initially have a written lease with Mr. Belogan?
Yes, in the beginning.
Okay.
And afterwards, we didn't. And I was not aware that there was a month-to-month lease because every time the year came for us to renew the lease, he said that he would bring the copy of a lease for me to sign, and he never did.
Right. So you never signed a new lease but continued to remain there. Is that correct?
Right, because he always stated that he was going to bring,
that's fine. How much is monthly rent?
$1,000.
Are you aware of any late fee?
No, I was not.
Okay. Last time you made a payment?
The last payment that was made was in August of last year.
Okay, and for how much do you recall?
That was the amount of $3,000 that was given to him.
Okay.
And him and I and my husband, we had discussed it and talked about it, but he seemed like he's not aware of the situation. That's why I said I had my husband online.
Well, hold on. Hold on. I don't even know what situation you're referring to. So oftentimes you have a huge background, right, with this person. I don't know nothing about it other than what's in the paperwork. So just hold tight so I can connect the dots appropriately. I'm going to ask you some additional questions, okay? What you're saying is when you made that $3,000 payment, was that to bring you current or through August, or was it going to bring you current through maybe like January or a December or February of 2025?
No, it was going to bring me current to August.
Okay.
Yes.
So you haven't paid for a minimum September, October, November, December, January, or at least those 5 months.
Yes.
And I believe that's what you've alleged in the answer as well. Is that correct?
Yes.
I think you at the time put the correct amount of past due was $5,000, I think is what you put on your answer.
Yes, because at that time, that's how much it was. That's how much it was, 5,000. But because it's March now, it made it 7,000.
I understand. Now you've also, and I'm just going to address each of these things on your answer. You indicated as well that he did not provide you a written demand. Is that correct?
I didn't hear you, sir. Repeat that again.
You also indicated on your on your answer that you were not provided with a demand of possession, a 3-day demand.
Right. He did not give me, yes, he did not notify me. Exactly.
Okay. And so how did you find out about this action?
Because when I got off work that morning, I saw the marshals pull up in the driveway and I said, "Excuse me, who are you looking for?" He said, "I'm looking for Muhammad." And I said, I'm Muhammad. And he said, you've been served. And that's when he gave me the letter. And I said, oh, wow, he's sending me a eviction letter after we had already talked and discussed that I was trying to get help and assistance and everything for me to help pay the back rent. Okay. But I wasn't able to get any assistance. And then I got robbed in November. And I let him know that.
Okay. All right. Well, I'm sorry that you were robbed. And
I have a police.
I got it, but I'm not disbelieving. Oh. That's not really as relevant right now, but I hate that happened to you. But hold tight. So let me first, just before we move forward with the next portion, Mr. Below, she's alleging in her answer that you did not provide her the appropriate and required 3-day demand letter. So did you provide that letter to her, and if so, how?
Yes, I did. Talk to her. This started like middle of last year.
No, listen. And I'm not trying to be rude, but these are simple questions. If you provided her the 3-day demand letter, just tell me when, and tell me how. It can't be oral. So if you're going to tell me you told her something, that's not going to be sufficient.
Okay, it was oral. So
okay. Yeah. All right. Okay, thank you. Any other, and no other written notice to her?
No.
Okay. Oh. And then finally, Ms. Muhammad, I understand you also identified that you had over $62,000 of for counterclaims for failure to repair. That's more than the rent that was owed. So tell me what's going on. I did see some issues with that. Tell me what's going on with that.
Yes, in my counterclaim, as you saw when I had wrote and told you, that I had wrote and everything stating that,
written, you freaking scammer, written. Oh my God, get her out.
Been paying the landlord, money for the rent. And I came to that amount because my water bill is over $35,000 due to him not repairing the leaks in the property. So when I first moved in the house, he was aware of the situation for the leak, and he had somebody to come over there, but it was still leaking afterwards, because when I informed the water company, they told me that water was still running. So they even sent somebody out to see what the problem was. And when they did that, I called Mr. Barnigan immediately after the people had left and letting him know what the situation was with the water. So my bill kept going up and up and up to $35,000.
Take a pause, hold on. So one, I wanted to ask, is the water in your name?
Yes, it is. It's in my name.
Okay. And when did you see that your water bill began to grow? Well, let me ask you this. When's the last time you paid a water bill?
Well, I didn't pay anything on the water bill.
Okay, but when is the last time? Wait, why do people answer the question I ask, not the question you hear, right? I ask, right? When is the last time you paid your water bill?
I didn't pay any water bill.
So you've never paid a water bill?
No, I never paid the water bill because when I first moved in here and I asked them, did I have a bill? They told me that I had to wait and everything until they adjust my bill. So that's why I never paid the bill. And of course,
how long have you been living now?
I've been living here since February of 23.
So you haven't paid a water bill since February of 23?
No.
Okay.
No, I didn't pay anything.
Okay, hold on. I just want to make sure I understand your position. You're saying there's a leak, but you didn't. But when did the leak occur? When did you discover that
the leak occurred in February, and that's when
year?
I first moved. February of 23.
Okay.
And that's when I had told him.
Okay.
Like when I was getting everything, turned on, connected on, from my old place, from my old address to here and everything about.
So when they sent you your first bill, you just said, I'm not going to pay it?
No, when they sent the first bill, I wasn't aware of it because
what
of the
about
fact
the next month?
That's what I'm saying. I wasn't aware of the bill because of the simple fact that when I had called them, they told me that the water bill was in my landlord's name. And I said, no, because I'm the tenant, Mumina Muhammad.
When did you officially put it in your name?
No, always been in my name because they transferred over, to my old address to here.
I got it. So the concerns about the water, I'm going to pin that. What else are you alleging as your counterclaims?
Well, the money, I feel that, he should be paying me back some of my rent because all the money that I was paying for the rent, he kept telling me that he was going to fix and repair. And then he told me to go look for people, to come and fix, to look for an electrician, a plumber, a construction worker, which I did. I had spoke to,
an electrician. Jeez. How do these people get through? I guess they don't. I guess it's just they're all on government assistance and that's it.
A couple of electricians, a Muslim man that goes to our masjid, and it was a Spanish electrician named Jose.
Well,
and
let me stop you and just respectfully. That's relevant, but not really relevant. So let me tell you what we're going to do. One, I have concerns about your counterclaims because it sounds like a portion of it might be really rolled up in your responsibility of not paying the water bill. But that's another thing. The bigger issue, though, is before we can proceed, he has not sufficiently given you a demand of possession, which is an essential element of being able to even file this case. If he hasn't done that, then we technically can't proceed. Now, I could consider your counterclaims, but from what I've been hearing, it doesn't really arise to that issue, at least at this juncture, particularly when a portion of it sounds like they may just be unpaid water bills. And so I'm going to, at this juncture, just dismiss your your counterclaim without prejudice. That means if he files another claim, he'll be free to refile it and address these issues and maybe put them better in a better organized fashion. So it doesn't just appear as if you're kind of not paying the water bill, because that is a great concern for the court if you're telling me you haven't paid a water bill and been using and living in there since 2023. But nonetheless, we're going to dismiss the case because of the failure to demand, and I will dismiss the counterclaims without prejudice. And Mr. Belogan, if you've been aware of what's going on, you know that you had failed to demand, that's a required prong of being able to or satisfy before you file this action. So we'll see if you refile. Otherwise, I will put the order in. You guys will get a copy, and you're free to go.
Can I say one thing?
No, you can ask one thing, but not say one thing. What do you have to ask?
Well, I wanted to say something about the water bill.
Don't worry about that. That's not even currently. I listen. Like I said, I just briefly explored it. We haven't gotten fully into it. And as I said, I'm dismissing it without prejudice. That means you can bring it again. And if you haven't, maybe you're not clearly sure what's going on. Like you said, your husband's on the telephone. Maybe he needs to be here to better explain it. So since none of that is currently at present, we're going to go ahead and dismiss it without prejudice, and you can bring it again if you so desire. Okay?
Yeah, but my husband is sick and he's in another state.
So don't worry about it because that's not going to be dealt with today. But I'm going to let y'all go, and I'm going to get you a copy of the order.
Okay, thank you so much.
Thank you so much.
Let me tell you how that.
Oh, yes, sir.
Yeah. Can I do the notice on the text? Would that be good enough? Or
no, that will not be good enough. If you want to go look up what's required, OCGA section 44750, or you can just go look up in Google what is the statutory requirements for notice.
Attorney.
It's pretty simple, and it'll tell you. But no, text message is not going to suffice.
Thank you, sir.
No worries.
Stephen Stroya, City of Wyandotte versus Stephen Stroya, 2690.
I can't.
Attorney Corey Westmoreland, appearing on behalf of Mr. Stroya.
Mr. Stroya, your name for the record, please.
Stephen Stroya.
Okay. And so today is the date scheduled for sentencing on your client's plea to the count of disorderly conduct. The second charge of resisting and obstructing an officer was dismissed by way of resolution between the attorneys. And counsel, do you have an opportunity to review the report and recommendation with your client?
I did, Your Honor. And at this time, the report is factually accurate. There's no additions, deletions, or corrections that need to be made at this time. And I'd simply just ask that the recommendation be adopted on behalf of Mr. Stroya with consideration for 771.1.
All right, sir, I gotta ask. I mean, you're walking around without any shoes on, and you went into someone's yard to take a ladder.
I was just trying to get back to my place, and I got cut through a yard, and I was cold.
Well, sir, you live on Grosio.
Oh, my God. I used to live on Roseville.
All right, well, let me see here. Do we have your new address?
They have me tethered to his new address.
Interesting. When did you move to your new address, sir?
Well, I had been working on it.
When did you move to your new address?
I technically totally moved there on my tether day. I had been working.
What date?
January 20th.
Great. Okay. I don't know that we have your address, sir.
Oh, 376.
No. I need you to write it down on the sticky note so we can make sure we have because we still have your address in Grosio.
Oh, sorry about that.
All right. Do you know Miss Campbell?
No.
Okay. Is Miss Campbell here? No. Okay. All right. And sir, were you intoxicated that day?
I was not intoxicated. I had eaten some RSO.
RSO?
It's a cancer treatment for my sister-in-law for brain cancer. It's a pot derivative. It's very strong. I was
Do you have cancer?
My sister-in-law has brain cancer.
No, you have cancer.
I do not.
So why would you take medicine that's not
to get high
for you?
They were trying to figure out the dosage to give her. I said I would try it. And I still.
That was the dosage guinea pig, Judge.
to try to figure out the dosage for somebody else.
Yes.
Did you realize how
he's a giver. He's a giver.
It sounds silly, yes, but she was in very bad condition and they were trying to figure something out for my brother.
Okay.
Oh, Judge, he's also a coke tester.
Sir, I can understand that, right? But I'm going to presume that you're a different size than your sister-in-law.
Yes, I do.
Right. And you have different medical issues than your sister-in-law.
You're correct.
So why in the world did you think for you to try that is going to help figure out the dosage for somebody else?
They figured if it didn't affect me super strong, then it would, they could figure it out for her. They didn't have the true recommendation for it.
Okay.
Obviously, good thinking wasn't done.
I certainly hope that who's ever
This is so stupid. Oh my God.
thought process that is working on changing that thought process.
No, correct.
All right. The court's going to note after hearing from counsel reviewing the report, the recommendation that it is that there is reasonable grounds to depart from MCL 769.5, especially based upon the 771.1 status, which your client is eligible for. The court will also note that the following sentence is in the best interest of justice, is reasonable and appropriate, and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Stroya. And the court's going to order that you're not to possess or consume any alcohol or drugs unless prescribed. That would mean RSO, sir, just so you're aware. If you're not prescribed it, that's not for you. And the rehabilitative goal for that condition, so you can the court can monitor the progress in maintaining abstinence and sobriety. And then the court's going to also order you to participate in an anger management class. The rehabilitative goal for that condition, sir, is so you can learn proper coping or more appropriate ways to express your feelings and needs when you are in an upsetting situation. And the court's going to also order 3 days on the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and get back to the community. Okay. All right. Any questions regarding those conditions?
One question for the workforce, is it the same as community service for other groups?
Not necessarily.
Okay, because he had mentioned community service. So do they do that extra also?
No, I didn't order both.
Oh, okay.
No, I didn't order both. Okay. So what'll happen, sir, is you'll be with a group, and then you'll go to whether it's Wyandotte or Riverview to perform whatever work needs to be performed.
Okay.
Okay. All right. You're welcome. The court's going to order a $300 fine, $100 screening assessment fee, supervision oversight fee of $450. That's $50 in 9 months since you're eligible for early discharge. Up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, $120 for the workforce. That's 3 days at $40 a day. So that's $1,395, I believe, if my math is correct. Probation will correct me if I'm wrong. All right. Since I did indicate you're eligible for early discharge, you're eligible for early discharge as long as all of the following have occurred. You completed at least half of the original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. Okay. Any questions, sir?
That was 3 months to have it all paid in full?
No. You have, you can request early discharge as long as you haven't had any violations for 3 months before you request that early discharge.
I was just curious when I have to have it paid in full.
Probation will give you all that information, sir.
Okay, thank you.
All right, good luck to you, sir.
Your Honor, he currently has a GPS tether. Obviously,
The tether can be removed.
okay. Thank you, Judge.
You're welcome. Okay, and then we are on the record in the matter of the City of Wyandotte versus Darvell Martin, 251042.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. Martin.
All right, thank you. And sir, your name for the record, please.
Martin.
Okay, and so today is the date scheduled for a jail review. This court ordered your client, well, let me clarify. On January 12th of 2026, this court, for your client's plea to an amended charge of operating while visibly impaired, this court sentenced your client to 60 days jail, suspended. Your client was to participate in random testing, complete treatment as ordered through parole. He was attested on site in Lincoln Park. This court, and then we had a jail review scheduled for today. January 26th, there was an expedited jail review.
The absolute stupidest people who ever lived. That's what you missed, Andrea. If you don't believe me, go back to the beginning and give it a watch.
Based upon your client's failure to set up testing. At that time, this court ordered your client to set up the testing on that day or serve jail. Your client was also ordered to provide proof of continued treatment, and he has not done so. He did, however, begin testing on January 26th. January 26th, he was positive for marijuana. February 6th, he was positive for marijuana at a higher level and alcohol. February 24th, positive for marijuana at a higher rate and positive for alcohol. And March 6th, positive for marijuana, yet at a reduced level, and positive for alcohol. And so, counsel?
Yes, Your Honor. I would like you to know that Mr. Martin was released from parole at the end of January. He does have a valid medical marijuana card. He is gainfully employed working as a manager at Fast Flash Car Wash in Southfield. He has not accrued any new charges. He also is a father of 2 that he's responsible for, and he's just been working on keeping his life on track and staying out of trouble. So at this point, I'm not really sure what's left for him to do.
I'll comply with this court's order is one thing, Mr. Martin. But let me ask this question, sir. How long have you had your medical marijuana card?
I'm not sure, since February or something. I know it had lapsed.
February of this year?
Yeah, I know it had lapsed, so I had to get it redone. But
Great. Did you submit proof of that to this court?
I have it with me today.
That wasn't my question.
No, I didn't.
Then you can't use it, sir. This court ordered not to possess or consume any drugs or alcohol that are not prescribed. At that time, you did not have a valid medical marijuana card. That way, that means, sir, that if you want to use it for medical purposes, this court needs to verify that it's from your treating physician and that that's the recommended course of treatment. All this court requires is a letter from your treating physician. You don't even have to go through all the steps of the card.
Yes.
Did you get your card from a treating physician or from a local marijuana clinic?
I get it from a physician.
Okay, somebody that treats you on a regular basis, sir?
Well, no, they contacted my doctor from Ohio because I had a card there lapsed. So they had to get my information from them. Then they transferred it here, and that's how I got it.
Okay, the doctor from Ohio, was that your treating physician or a medical marijuana clinic doctor?
He was my physician at the time. I mean, I had him for a few years, but I haven't had him since. I've been here for over a year now, well, over 2 years now.
Okay, let me clarify a little bit further. Is he your doctor
He was
for,
my actual
excuse me,
doctor.
let me finish, please. Is he your doctor for all things or for only marijuana purposes?
All things.
Okay. And so, do you have anything from that doctor that recommends that that's the course of treatment for you?
Not long, you know.
Okay. In any event, you don't have a prescription for alcohol, is that correct?
Absolutely correct.
Okay. So even despite your marijuana tests that are positive, you've continued to use alcohol where this court's ordered you not to use alcohol.
Can I speak, please? You told me to follow my guidelines of my parole. That's what you told me to do. Once I was released off parole, there are no more guidelines. That's what you told me to do. I listened to everything you said verbally, word for word. I did it exactly the way you told me. I don't have parole anymore, so I don't have those guidelines. I've paid my fines each month and I completed my treatment as well.
You didn't provide proof of that, sir. Why not? You were ordered to provide proof of that.
I've lapsed on mine, but I have the proof as well.
Sir, I am confident that I instructed you not to possess or consume any alcohol or drugs unless prescribed and to follow your parole conditions as well. And you were to complete treatment and provide proof. You were also to set up random testing. So even though this court indicated you were to follow your parole conditions as well, this court's order of not to possess or consume any alcohol or drugs that are not prescribed continued. So did your having to provide proof of treatment continued, as well as your random testing continued, because that's an order of this court.
I just don't understand if I'm not on probation or parole. I feel like I honestly, in my mind, I don't think I'm doing anything wrong if I'm not on probation or parole. Like, that's literally how I see it. You're telling me that I'm wrong. But while I was out there, I'm thinking I'm not on probation and I'm not on parole. I've completed everything they've asked me to do. What am I doing wrong here?
Well, sir, the recommendation at your sentencing on January 12th was incarceration. This court ordered 60 days jail, but the court suspended your jail. Court suspended jail, and the court gave you conditions to remain out of jail. That was not to possess or consume any alcohol or drugs unless prescribed, to complete your random testing, and to continue with your treatment.
I didn't think it was possible, but they keep getting dumber. I didn't even think it was possible. The next defendant is just going to crawl out like an amoeba and just drool on the carpet. I don't know where else we can go with this.
And provide proof to this court. So the court said that you had to do those three things to remain out of jail. So while you're not on technical probation, this court had orders that you needed to follow to remain out of jail. That's what that was. And you didn't follow those.
Judge, I don't understand. Could you explain that again, please?
I completed the treatment. I've paid my fines as you told me to, each month. I've done that as well.
And you continue to use alcohol.
Correct.
And this court ordered you not to use any alcohol.
So if you're gonna take me to jail, can you give me a second to get my bills and stuff taken care of and I go to jail? That's where I see this is going. So can I just get myself situated, please?
You need to turn yourself into jail right now.
The court's going to order Mr. Martin to serve 30 days jail.
The wheels of justice are going to roll you right into the Wayne County Jail.
If you report on Friday, is that enough time, sir?
Yeah, I'll be right.
Is that enough time for you to get your bills in order?
Yeah. I just have to really pretty much go pull money out of the bank, get it to where it needs to be.
All right. So I'm going to indicate report March 20th. You're going to stop at probation. They're going to give you the directions for reporting. Have a good day.
Thank you, Judge.
You're
Thanks
welcome.
for playing, big dummy. Okay. Surely this guy will come through for us and save the day. He's going to come up with a brilliant defense.
All right, this is 22.
And O'Donnell's going to say hallelujah and escort him out into the free world. That's my prediction.
455 Justin Poole, violation of community control. First violation, failed to report October 7 and thereafter. You understand that charge?
Yes, Your Honor.
Second, home visit was attempted October 23rd, and you did not live at that address nor provide a alternate address. You understand that charge?
Yes, Your Honor.
Ms. Novotny?
Your Honor, at this time, my client would like to waive both hearings and admit to the violation.
Is that what you want to do?
Yes, Your Honor.
All right, what's your plea to those allegations?
Guilty.
I'll accept your guilty plea and find you guilty. What seems to be the problem?
I started drinking a little bit and I was behind on my rent. So instead of facing my consequences, I chose to run from them. And here we are.
That was a good long-term solution.
No, no, it wasn't.
Okay.
Yeah, you know, we do things sometimes when we're scared. We don't think in the moment.
What are you scared of?
I don't know, because I had a good relationship with Miss Newman, my former probation officer. I'm not really sure what I was scared of, the consequences of my actions, because I had prior seen you about leaving a different sober living house, and seeing you 2 times in a row on the same thing seemed like a bad idea at the time.
Well, did you think you were never going to see me again?
No.
Why did you leave the sober living this time?
Non-payment. That'd be the time I found a job at, I worked at a meat cutting place called Barb and Patty's.
Right.
The rent was like $700. It'd be the time I found the job, I was almost a little over $1,100 in the hole. And they take, at the Jeff's house, they take the payment thing very seriously. The second you get X amount of dollars behind you, you have to leave within 24 hours anyways.
Okay. And so then naturally the thing you thought to do was call your probation officer and discuss that problem with her, right?
No.
No. And so what'd you do then for the last 4 months, 5 months?
I've been living with my dad. I was looking for work a little bit. I was actually in the hospital with a staph infection in my face for the end of December into the middle of January, until I figured out my insurance My insurance lapsed. I left there. I got a $90,000 bill in the mail. And then I went to go reapply for Medicaid and my food stamps mid-February. And I was told, you can't get back on health care and stuff with a warrant out for your arrest due to new policies, which I didn't know. So when police came to my house, I just opened the door. I have bad heart disease and stuff. I can't live without health insurance. So that it was the end of the line, and I took it instead of running or hiding again.
So why did you stop working at Barb and Patty's?
Because I moved back to my dad's house. I have no transportation back to Menor.
Damn. I thought we had this bus system called Lake Tran.
Yeah.
Did you ever utilize that?
No.
Why not?
I don't know. I've never ridden the public buses.
So? Why don't you drive a car?
I owe a lot of money.
Why?
Past court fines. They all got sent to the Attorney General's office, and you had to pay lump sums there.
Is that right?
Which
Did you talk to somebody at the Attorney General's office?
Yes, Your Honor.
It seems like you have no interest in digging yourself out of this hole.
I believe it would take far too long.
Okay, so what now?
I don't know. I don't know what now.
Why else did you get booted out of sober living?
That was it, just the drinking and non-payment.
You said, well, you only told me the non-payment. What's the drinking thing?
The drinking, I said I started drinking again was one of the first things I said.
Okay. See, I lost track of you, okay? Because you're on page 2 of a docket sheet.
Right.
So did you have something at the sober living that got you in trouble with them?
Yeah, I found a beer can.
A beer can. What kind of beer?
A Four Loko, I believe.
What the hell's a Four Loko?
A beer?
A beer? I never heard.
I think it's a malt liquor. I don't know.
What's your heart problem?
I mean, I have the valves now, but it was aortal valve something and mitral valve something. So I got the mechanical valves changed out. I had a heart murmur, which is a hole in your heart, which they patched. And now I'm on blood thinners.
And one of the things you can't understand is why you can't smoke dope. Why do you wonder that?
It's not that I can't understand it. It's that it doesn't affect my life like doing cocaine did. Like the first time I saw you when I was doing that, it's not.
It's not what?
It doesn't adversely affect my life or my relationship with my family.
You're in fucking jail.
Yeah.
How has it not affected your life?
I don't constitute it to smoking pot.
You don't. Well, goddamn, you got a pretty good handle on what's going on. You're 32 years old, going on 33. You're in jail because you're afraid to show up to things. You got a long record, and you got a good grip on what's good and what's not good. That's great. It works out well. Your plan in life seems to be not what am I going to do tomorrow? What am I going to do an hour from now? Because all you're trying to figure out right now is how to get the hell out of jail as soon as possible and get off of probation as soon as possible. So what's your method? What's your solution to getting off of probation as soon as possible?
To run the timeout on the probation clock.
How do you run the timeout on the probation?
You do the time on your case.
You do the time where?
Wherever you can. It's a felony, so prison.
Okay. And what awaits you in prison?
Not sure. I haven't been there.
Not sure.
It's better than
you're afraid to show up here, but you're not afraid to go to prison. No?
No.
All right. Then what's your plan after you get out of prison?
Find a job and continue working, pay off my giant court fee or attorney general fees and get my license back and continue on with my life.
Why didn't you do that while you were on probation?
I was doing it slowly. Except for the sober living, I've done everything that you've ever tasked me to do.
Oh, well.
NeoCap,
Didn't show
IOP,
up.
aftercare.
You don't like showing up.
Yeah.
So what good did all that stuff do if you're of the belief that you should be able to drink and smoke pot?
It got me off hard drugs. It helped me repair the relationship with my family. I sowed new friendships. And
how much pot were you smoking while you've been gone for the last 5-6 months?
Not that much.
Well, how much?
It's just a couple grams a week because I wasn't working. So
what does that have to do with it?
So I'm not blowing tons of money on pot. I have other things I need to pay for, such as the court fines or attorney general fees, I should say.
So how much money were you spending a week on that?
None. I know people that grow it, so none, to be honest.
Okay. So what good did any of this treatment do?
It got me.
If you're going to go out and smoke pot.
It got me off cocaine, which adversely affected my life way worse than
the cure to getting people off of cocaine and heroin and whatever else is letting them smoke pot.
I don't know. Everybody's cure would be different, I suppose.
Any of this treatment that you went through, anybody ever talk about insight? Remember that term, insight?
Yeah.
And what do you know about insight?
Everybody has a different version of it.
A version of it?
Yeah.
What's your version of it?
My version of it is I could see things one way and someone else can see things another way.
Okay. How's your way working out so far?
I don't know. I haven't been off probation in a very long time.
Well, your way's not working out.
Okay.
Because you're in jail again.
Mm-hmm.
I know you don't believe that, but it's objectively true.
I can't deny it. I'm sitting here in shackles and handcuffs.
Right. But you don't believe it. You just won't deny it. Because you have no insight into what the situation is, what your problem is, how to get out of your problem, how to begin to dig out of the hole that you've created over 32, 33 years. Because you don't have any interest in doing that, okay? You had a pretty good opportunity at this Barb and Patty's place to learn how to be a butcher.
Mm-hmm.
And you pissed that away for why? Why'd you do that?
Because I run from consequences. I guess it's what I'm good at.
All right. Well, you're not good at it because you're caught.
Mm-hmm.
You're here again. How many days on this felony 5 have you spent in jail?
244, 43, something like that.
So you've eaten up 8 out of 12 possible months, and have really haven't accomplished anything. You think you've accomplished something because you tell me you haven't taken any cocaine since you've been gone. Of course, I have no way to verify that because you've been gone. You know, when you got caught, you wouldn't take a screen. So that tells me quite a bit. Of course, you give me the eye roll like, you know, I'm out of my mind, and to believe that you were using cocaine out there.
Craig Berry visited me, I believe 2 days or 3 days, and I tried to pee for him. He waited all 40 to 70 seconds and then said, well, you gave it a try. And
so
left.
It's Craig Berry's fault.
I'm telling you factually what happened. I'm not saying it is anyone's fault.
You're not a good factual reporter.
Mm.
Ms. Novotny?
Your Honor, we would just ask for any leniency when it comes to the probation violation in front of you. From my understanding, he does have a total of 243 days of credit. I know in the time being, he was trying to achieve or get a job with Goodwill or Marks before the violation occurred. I know sober living became very expensive for him as well. He was living, from my understanding, with his parents. With that, he does have a lot of medical issues dealing with his heart disease, congenital heart disease, previous valve replacement.
He's not only concerned about his medical problems because he's out drinking 4 Locos and smoking pot. So his medical condition is secondary to you.
He also has previous valve replacements and endocarditis. He's on blood thinners for the rest of his life. With that, Your Honor, he was doing counseling with Lake Geauga. He does have a support system that is present in the back of this courtroom. We're just asking for any type of leniency today.
What good does a support system do if you won't utilize the support system?
I do.
You do. How? Smoking pot? Exactly how have you utilized your support system?
I talk to them when I feel like I'm going to do hard drugs and things like that.
And they tell you just smoke some pot instead?
No, they don't.
How do you use your support system known as the probation department?
I don't see the probation department as a friend.
You don't. I didn't ask you if they were your friend. I said, how do you utilize the support system that is the probation department?
I went to my meetings. We're ignoring the fact that I showed up to tons of appointments, to hundreds of drug tests for a year, 2 years.
You haven't been there since September 23rd.
That's 4 months since 2023.
God's sake.
I wouldn't argue.
No insight.
That's not going to help you.
Zero insight. You're right, they're not your friend, but they're certainly not your enemy, although you treat them like your enemy. Who is your probation officer?
Nicole Randazzo, then Nicole Newman.
Right. Who is it now?
I don't know.
Because Nicole Newman left.
I don't know.
When did Nicole Newman leave, Kaylee? Do you remember?
Probably around November, I believe. Okay. Could have been October.
All right. All right. Anything else?
Yeah, you named someone who quit last year. It's too good.
You want to say?
Yeah, maybe you're right about me in some aspects, but I don't know. I don't know how to fix the problems your guys' way, I guess.
Well, you haven't fixed it your way.
Your guys is tack a year on to whatever you're going to give him here.
So maybe what you should have done was try it a different way.
I gave it a real good shot.
You didn't. You didn't.
You didn't. No.
You did.
Wrong. No, you didn't. I love it.
The only one that's going to fix you is you. You are no longer amenable to community control. I'm going to terminate your community control. I'm going to sentence you to 11 months in prison with credit for 243 days and the costs. So you won't have to report to probation anymore. And you can do whatever you want to the extent that you don't get caught. Because if you're going to stay around Lake County and you get caught, guess where you land again?
Mm-hmm.
All right.
Oh, that was beautiful. That was heartwarming. We ended on a high note. Good stuff. Lots of good stuff to stream today. All right. Tomorrow I plan on dealing with Afro Man if it's on. I assume it is. I would think they'd finish up that case tomorrow, but we've also got Taupe. So we'll see how we can deal with both of those. If they both start at about the same time, I'll probably do Taupe first and then just catch up on Afro Man because there'll be breaks during the day. That's my guess. That's my guess. Thank y'all for coming out. Thank you, Zach, for all that good stuff. I even have other good clips. I really do. That's just what happens. That's what happens when you're on trial, though, because then there's all these other good things that happen, and if you're streaming a trial, then you're doing that all day, and all this other material's developing. It's a good problem. It's a good fun problem. Thank y'all for coming out. I appreciate it.